Welcome to another edition of MissTrial. Three law partners, three friends, three former prosecutors, and one former member of Congress. I'm Karen Friedman Agnifilo, joined by Danya Perry and Kathleen Rice, and we're thrilled to be here again to talk about all things that are going on at the intersection of law and politics and give you the perspective, the unique perspective that we bring to all of this. Today, we have a lot to talk about, guys. Big news coming from Jack Smith, the special counsel. He has been really busy. He asked for more time in the Washington, D.C. case, and people were scratching their heads thinking, why does he need more time? Well, now we know, because he superseded the indictment against Donald Trump in order to be able to address the concerns that the United States Supreme Court brought, and literally making new law and presidential immunity, and so he superseded, meaning he changed the indictment in order to address those issues. And so we're going to talk about that in detail and really talk about how he has he has neutralized the issues in a brilliant way, I think, that were raised by the Supreme Court. So we're going to talk about that in detail. And the other thing he's been doing, again, very busy, is he's appealing the Mar-a-Lago dismissal to the 11th Circuit, and essentially calling out how Judge Eileen Cannon's interpretation of the law is wrong, and the case should be reinstated. So we're going to talk about that appeal and whether we think that is going to succeed. And finally, Kathleen Rice, our former member of Congress, the only one of us who's actually run for office and also held office, is going to talk about what's happening in Texas in particular, where we have people who are trying to do voter suppression through ballot harvesting, something I didn't even know was an issue. And so Kathleen is going to talk about how MAGA and the far right is literally trying to make it so that people's votes aren't counting, and what we can do about that. So we also love that people are asking us questions in leaving comments and questions. So we're not going to forget this time, but thank you for reminding me last time. We're not going to forget. We're going to answer some questions at the end. So great to see you guys. And there's nobody I'd rather discuss these important issues with than you. How's everyone doing?
Hey guys.
Great.
Great.
Hey, ladies.
Thought it was going to be a slow summer, but Jack's
Right.
a lot to chew on.
I know. We were like, maybe we'll skip this week because it's the weekend before Labor Day, but we can't.
Jack Smith is still working, so we're going to work too.
Exactly.
Let's talk into it. I mean, Karen, you said there's been these big developments in both the Mar-a-Lago case and the January 6th case. Nothing really is going to come to a head before the election. So if Trump wins that election, both these cases are going to be gone. If he loses, he'll probably face a trial. That's my view in both cases.
Explain to everybody why, if he wins, it's going to, why it's gone. It's because it is.
The Supreme Court has said that he has full immunity to take official acts, and they specifically called out his interactions with the Department of Justice as being completely immunized. And so, not so much by law, but by norms and by traditions, the president typically has stayed out of the Department of Justice, with Trump in his first term being a notable exception, and putting a heavy hand on a lot of things that his attorneys general did. But this time around, I think there can be no question he will direct the Department of Justice to get rid of both cases. And so while the other two cases that
he pardoned himself, right?
And that I think is less clear. He probably will. There's no precedent for any of this, right? It's not clear that he can, according to the legal scholars in this field. But it's certainly clear that, at least in my mind, that he will, and that will probably go to the Supreme Court. And I think we can guess that one, how that turns out. So I think that's right. But as we've discussed here, the two other cases that are pending against him, and they're still pending, is the New York State criminal case that where he was convicted by a jury of his peers of 34 felony counts. That's still pending in the sense that sentencing has not happened yet, and so that conviction has not been perfected. And then the Georgia state election fraud case. Both of those were brought by state and local prosecutors, and the Department of Justice really has no hand there, and so those cases would stick. But I think in the two cases that we're talking about that are at bar today, I think it's probably a pretty good guess that those cases are gone, if you will. So, so what did Jack Smith do? I think there was a lot of speculating about what he'd do in the wake of the Supreme Court's ruling. God, I can't believe it was only last month. I think it was July 1st, right, that they came out with it. We're still in August. Seems like a lifetime. So much has happened. But, wondering how this was going to go, they gave a couple of pointers, I'd say. As we've discussed here on this podcast, the Supreme Court ruled that Trump has absolute immunity for official acts. So anything that's, laid out in Article 2 of the Constitution, he can do whatever the hell he wants. And that there then was a kind of more amorphous middle area for acts that were in that perimeter of his official duties, but weren't quite core functions. And those were entitled to a presumption of immunity. And then, of course, there's purely personal acts which don't get immunized. They didn't give a lot of guidelines to the lower courts to say what is and is not official, other than they specifically called out Trump's interactions with the Justice Department and said those essentially have to go. So we weren't sure exactly what was going to happen. Would Judge Chutkan cut these down? Would Jack Smith, take a pass at cutting them down? And that's what did happen. He went back to a grand jury. When I say went back, it's a separate grand jury, the one that had been impaneled that indicted him last, I believe it was August, so it's been about a year. That grand jury expired. They have terms certain, and so that one is gone. So he had to go back in front of a different grand jury, and so a quorum of the grand juries there found that it was more likely than not that he had committed the crimes that had been charged originally. So here in this, what's called a superseding indictment, it just replaces the old one. And all four charges remain. I think that's important to underscore. The exact same criminal charges that were in the underlying of the original indictment remain in the superseding indictment, with count one, the main one being a conspiracy to defraud the United States. And there's a couple of modalities that were laid out in the first indictment, and those largely remain as well. The one that doesn't, and because the Supreme Court said they couldn't, are allegations that relate to Trump's attempt to pressure and to work with the Department of Justice for them in turn to pressure various state officials to certify fake electors and the like. So they are one of his main co-conspirators there, who was listed as an unindicted co-conspirator, but he's been identified as Jeffrey Clark, who's kind of an obscure functionary within the Department of Justice. He'd been in the civil division as an environmental lawyer, and he came to Trump's attention because he raised his hand as being, someone who would go along with whatever it was Trump wanted to do. In this case, overturn the valid results of the election. So Jeffrey Clark and Trump together, worked to pressure state officials. Famously, there was a letter that Clark had drafted that was to go to the Georgia legislature, which implied that there was widespread election-changing fraud. And Jeff Clark, it was someone that Trump had wanted to promote within the Department of Justice to be the acting attorney general. but there was a bit of, and I hate to use the term insurrection, but the higher ups at the Department of Justice said no, and that they would resign, and that other members of the Department of Justice would resign en masse, and it would be a very ugly look. So they stood tall, and Jeff Clark was stymied in his efforts, as was Trump. But so those allegations are out. Otherwise, it's really just a pared down version and a tweaked version of the original indictment. So the indictment no longer includes, as I said, the allegations that Trump tried to pressure DOJ and his attempt to make Clark the acting attorney general. Otherwise, what the allegations now do is present a more focused picture of who Trump was and in what capacity he was acting. And so the new indictment, superseding indictment, takes every opportunity to remind, the reader or eventually the jury that sits in judgment that Trump was acting as a candidate here. So all of the other allegations, spreading false conspiracy theories about voter fraud, organizing these fake alternate slates of electors, trying to get those fake electors' votes counted, those were all Trump acting in his capacity as a candidate, not as the chief executive. And so, so I don't think it changed that much. It's shorter. Prosecutors often take the opportunity in superseding indictments to kind of pare it down once they understand the case better and think that they understand better what will appeal to a jury. So, slimming it to win it is kind of the expression there. And so they've done a lot of that. So it's shorter. I think it's about 9 pages shorter. But really, it's just more focused and more sharpened. So you'll see, for example, with the Pence allegations, those stayed in. I think there was some speculation because the Supreme Court didn't give clear guidance about what it thought about whether or not allegations or evidence about Mike Pence could come in or not. Those stay in, and those are an important element of the charges. And so he's fighting to keep them in. But they make clear that Pence was acting in his legislative capacity as the president of the Senate, and not in his executive capacity as the vice president. So I think it does a lot of the work for Chutkan. Not that she, is afraid to roll up her sleeves. She's always, she can be counted on, I think, to do the work here and to get it done right. But basically, they now have a new indictment to present to her for her to pick through and say what's official, what's in the kind of the penumbra, that could be, that's entitled to immunity. If it's entitled to immunity, does it get immunity? And then, of course, what's purely private. So I think they did a lot of that work for her, at least presented their view of how they think, this should go. And then, I think in pretty short order, we'll see what she thinks. Tomorrow, Friday, the parties will file their proposals for how they believe the judge should proceed. And then the following week, on September 5th, Judge Chutkan will hold a status conference, and there we'll probably start to see how she thinks the Supreme Court's immunity test should apply. Eventually, we'll find out if she's going to hold an evidentiary hearing, as we've discussed, or not. But at a minimum, she is required to rule about whether his speech was official or unofficial, and that is a fact-based inquiry. And so, one way or another, she's going to have to make some rulings as a question of fact, and then, of course, given the brand new rubric that the Supreme Court has just provided, how those facts adhere to the legal structure of that we now have.
So Trump has to be arraigned on the new indictment, right?
Correct.
How does that work? Because Jack Smith, I think, said he doesn't have to. They're not going to object if he doesn't want to appear.
Right. So he will have to appear. I mean, it doesn't have to be at the status conference. She can just hold a separate arraignment. Sometimes that's even kicked down to a magistrate judge, although in this case, probably not. But he and his co-defendants will have to. I'm sorry, there's no co-defendants in this case. That's in the Mar-a-Lago case. It's just him. There's a bunch of unindicted co-conspirators, one fewer now. But he'll have to appear, and he'll have to plead guilty or not guilty. And she'll remind him of his rights and obligations. And so that has not been set yet, as far as I'm aware. I didn't check the docket this morning, but I don't
But
believe.
Danya, won't he want to show up? I mean, this is another attempt for him to kind of, get the masses, the MAGA group, fired up, right? Or no?
Yeah, you would think, his court appearances really have not had that kind of, I appeared for over a week at the New York criminal case. Karen, you were there. There was a small amount of, of protesters and supporters out there, but not a lot. I don't think there really has been at any of his appearances. So,
No,
and
there
maybe
haven't
that's
been
because
but what happens is, but what happens is, he stands outside and gives a speech, and of course everybody covers it. So it's like free press, that he can just talk about what a victim he is and how this is political persecution. He just, his regular talking points is what he does. And, it's almost appalling and atrocious, because that's what you hear. And he lies about what is said in court. I mean, he did that in the New York prosecution, right? Remember when his lawyer said, "Oh, can he go to his son's graduation?" And the judge said, "I'll let you know. I'm not ruling right now." He goes outside and says, the judge won't let me go to my own son's graduation. And I read the transcripts because I couldn't believe that is actually the case. And he just flat out lied. And of course, he did go to the graduation ultimately. So that's what I hate about this kind of thing is every court appearance, everybody is like, oh, we have to cover it in detail. And the lies just get spread, and people are just kind of immune to it or used to it. I don't know. But he just gets away with all his lies, saying things are misinformation and disinformation and political persecution. He's already starting that with this superseding indictment. He started, furiously tweeting. You could tell it really got under his skin, but he was repeating the same talking points, again, saying all of those things. And then he said something about, the DOJ is violating their 60-day rule by bringing this indictment. Again, it's just a total mischaracterization of what that rule is, right?
Yes, that's not what the 60-day rule is. Not like he's so steeped in internal Justice Department policies, but the 60-day rule typically is that that the government will not go public with an investigation or a prosecution within 60 days of an election if the target of that investigation is running for office. That's obviously not this. This has been public for over a year now.
Exactly.
So that's obviously, just a complete mischaracterization, or as you say, lie.
But that's what's so frustrating to me, and I've said this before, like, I don't have a problem disagreeing on policy or facts, right? I believe in fracking. I don't believe in fracking, those types of things, right? And you can talk about it, but at least talk about the truth, talk about the same set of facts, and then form your opinion, right? That's what frustrates me about him is just the total lies and mischaracterizations that then get repeated over and over and over again as if they're true. If everyone's saying it, there are people who don't do deep dives and read all the transcripts. And they say, I have members of my family who are like, yes, but so many people are saying it, so it must be true. And it's just this way of getting misinformation out there that, has really been effective for MAGA.
To your point, Karen, I remember it was shortly after Trump took office in 2016, and Kellyanne Conway was working for him at the time at the White House. And she was asked about a specific incident that was a factual incident. And her response was, I will never forget it, well, we have alternative facts. And the person, I forget who it was interviewing, said, alternative facts? Wait, a fact is a fact. So,
Exactly.
Did we land on the moon? That used to be a fact. I don't know. Do people believe that anymore? Is there such a thing as a provable fact anymore?
Yeah. I mean,
Yeah.
it's just unbelievable to me. And anyway, but back to the superseding indictment. So he has to be arraigned on it. And so, what do you think Judge Chutkan is going to do? Do you think she can make these determinations on the whether the presumptive category and it may or may not be official category and the evidentiary category? Jack Smith was talking about he clarified things like in the new superseding indictment. He says things like, oh, he used his presidential Twitter account sometimes for personal and sometimes for official business. And he clarified that because the new law says if it was official, you can't even use the evidence to prove unofficial. So Jack Smith in this new indictment really clarified things like that. But how do you think she will rule? Do you think she will have a mini hearing or trial on some of the remaining issues, or do you think she can rule from the papers? I know it's unprecedented, right? And this is new area, but just do you have any thoughts on that?
Yeah, just to your point, just to give an example of the way in which he clarified, you just raised that. Here's the way the special counsel now talks about the president. This is a new line, for example, the former president. The defendant had no official responsibilities related to the certification proceeding, but he did have a personal interest as a candidate in being named the winner of the election. So that's a line that wasn't in the original indictment. And so you see that as a through line throughout the indictment. So I think it probably will provide some clarity for the judge. And, she's got a wide berth here. She has a tremendous amount of discretion, as trial courts do, and particularly when there really is no precedent. We had talked on this podcast about the possibility that Jack Smith would request an evidentiary hearing to really refine these issues and provide clarity for the judge. We've heard that maybe he won't be doing that, and you could understand that, right? It gives obviously a preview to the defense, like a roadmap of what people are going to say, and then they're on record, and then they can be cross-examined if there's any even minor or superficial inconsistencies. So you could see why he wouldn't want to do that. But ultimately, she's just going to have to look at each of these allegations and say, this is clearly official, this is clearly personal, or I'm not sure. And in those categories, if any, where she's not sure and where the parties don't agree, she could try and see what areas of agreement there are, which Justice Amy Coney Barrett did very cleverly at oral argument before the Supreme Court. Maybe she could see that, but I think we're not going to get complete agreement on what is and is not immunized. So she, with that bucket, whatever she's left with of that kind of nebulous middle ground, she can see if she can decide, on what she has in front of her, or if she needs additional information, like about, Mike Pence, the conversations that he had with Trump. What capacity was that in? If it's clear from the papers to her, and again, Smith tried to make that more clear that he was acting in a legislative function and not an executive one, maybe that will be enough for her. But, maybe she'll want to hear from Mike Pence himself or some of his advisors.
And so then what happens? Let's say she makes the ruling. It's appealable, right? So then he gets to appeal. And does he go to the DC Circuit, or does it go straight to the Supreme Court? I mean, what happens then? I guess
it could go either way. I mean, last time Jack Smith tried to leapfrog the 11th Circuit and basically appealed to the Supreme Court and said, look, justices, you're going to hear this case eventually. Let's just expedite. That did not happen. So I suppose it's a possibility this time around, but I think unlikely. So,
neither party can appeal, right?
Yes. And I mean, they absolutely can, and one party in all likelihood will. So it will end up back at the Supreme Court. But here, look,
so this could be years. This could be years before this trial.
He'll just dismiss it and then it's done, right?
Well,
right.
If he wins, yeah.
It could be some time. I mean, we see how attenuated this was. I mean, it was much longer than it needed to be. with the Supreme Court. They could have expedited, they could have sidestepped the 11th Circuit, the Intermediate Court of Appeals. They could have issued their ruling much more quickly rather than wait till literally the last day of the term. Then they could have, then there had to be a mandate to go back down to the district court. That took, the maximum amount of time possible. So that seems like a deliberate slow walk. After the election, will they be as motivated to, slow this down? Who knows? But yes, it could take some time. I don't know about years, but a lot of cases do take years, right, to go up and down the circuits. This one, as much as I just said, it was a slow walk. It was done within, the indictment was just last August. It was slow in the sense that it could and should have been much quicker. Supreme Court is capable when it wants to act much more expeditiously. They just chose not to this time.
Yeah. Wow, it's a big deal. So one other question, the thing that surprised me about this is, given the fact that this is going to take forever and we're not going to trial anytime soon, why didn't he indict the unindicted co-conspirators?
Yeah, great question. I know. And you had put that out there as a possibility of the reason why these, the unindicted co-conspirators were unindicted, and that it was possible that it was really to try and expedite this. Obviously, that's not really an issue anymore. I don't know. I mean, sometimes people are left unindicted in the main target's indictment because there's some hope that they'll testify and cooperate. We don't know really what's going on with that, although some of the so-called unindicted co-conspirators like Eastman and Giuliani don't appear to be cooperating. So it's pretty inscrutable what the deliberative process there was in the discretion and Jack Smith's exercise of discretion. I don't know. Maybe there'll be a separate one.
Wow,
so,
incredible!
Absolutely. So that's another Jack Smith news, Karen.
Another Jack Smith news. Yeah. So Mar-a-Lago is, he's appealing this dismissal of Mar-a-Lago. And I am going to talk a lot about that. But first, we're going to take our ad break because we have these amazing pro-democracy sponsors. So stay tuned to hear all about Mar-a-Lago. But let's just take a quick break. Dry skin, deeper wrinkles, crepiness. These are just a few things that are visible signs of aging, something that today's sponsor, OneSkin, knows all about. Now, I, unfortunately, because I'm on television, I now notice these things about myself. I used to not really think about it or care, but now that I have a podcast, I notice my skin and I notice that I'm aging. I just turned 58 years old and I love this sponsor, OneSkin. This is a cream that I put on my face every single day, and people have started noticing that I actually am reversing the signs of aging on my skin. So I really love this sponsor. They're amazing. This is something that goes into skin longevity and into the cellular aspect of trying to repair what your skin naturally does as we age. There's something called senescence cells that you start accumulating as you age. Some people call them zombie cells, and they stop producing collagen and hyaluronic acid like they used to. So they start secreting an inflammatory substance that makes other cells not work as well as they could. And OneSkin targets these zombie cells. It was founded by an all-woman team of scientists. MissTrial loves that since we're all women. And OneSkin is the first and only skin longevity company to target cellular senescence, a key hallmark of aging, with their proprietary OS1 peptide. It's scientifically proven to decrease lines and wrinkles, boost hydration, and help with the thinning skin that often comes with age. Don't just take my word for it. They've got over 5,000 five-star reviews, and they have a whole line of full-body products. You can also ask my mother, who noticed, actually. She said, "What are you doing to your skin?" And if my mother notices and she says it, it must be true. So rather than treat the symptoms, treat the root cause of aging, and try this cutting edge OneSkin. I really love it. I use it every day, and I am beyond thrilled that they are sponsoring our podcast, MissTrial, that they're pro-democracy sponsors, and you can keep your skin looking and acting younger for longer. Get started with 15% off using code MissTrial. That's MISSTRIAL at oneskin.co. That's 15% off with code MISSTRIAL at oneskin.co, not com.co. Thank you so much, OneSkin, for sponsoring this podcast. If the summer heat has you worrying about the strength of your deodorant, listen up. I'm about to tell you about the only deodorant you'll ever need. It's called Lumi Whole Body Deodorant, and it's formulated for all the places that tend to get a little smelly when the weather warms up, like your pits, your privates, or your feet. Not only does it go where other deodorants don't, it's also outrageously effective. One application in the morning is clinically proven to block odor all day. So even if the summer feels like you're in Texas or Louisiana, or you literally are in Texas or Louisiana, you don't need to worry. Lumi has you covered with up to 72 hours of odor control. So make this your freshest summer ever. They have amazing scents like clean tangerine, lavender sage, or toasted coconut. And there's a special offer now for new customers who get 15% off all Lumi products with our exclusive code and link. Use code MissTrial, that's with 2 S's, MISSTRIAL, one word, at Lumi, Lume deodorant.com. That's LumeDeodorant.com, and use code MissTrial, MISSTRIAL, at checkout so that you get 15% off. I love that it's safe to use anywhere on your body, created by an OBGYN, and it's pH balanced and safe to use even below the belt. So try Lumi. You can do this starter pack, which is also great for new customers. It comes with a solid stick deodorant, a cream tube deodorant, and 2 free products of your choice. So it's free shipping, and you get 15% off with this special code MissTrial. So again, go to LumeDeodorant.com and put in code MissTrial. Thank you so much, Lumi, for sponsoring this podcast. All right. We're back. So Mar-a-Lago has been dismissed. Judge Cannon took the invitation from Clarence Thomas, who in this immunity decision wrote a concurring opinion saying, I agree with immunity, but let me just add a topic that was not briefed. I think that the special counsel is illegitimate and cannot be appointed, and literally just took up this issue that had nothing to do with the immunity decision, in the sense that nobody brought it up, nobody briefed it, it wasn't part of our oral argument, but he decides to throw it in and literally gave a roadmap to Judge Cannon, who clearly took it. I mean, it's like a love letter to her in a sense, and gave her permission essentially to say, basically ignore all precedent, ignore what's been going on in this country forever, ignore the law, ignore the Constitution. And the timing was just so absolutely political. She waited until the day of the Republican National Convention, okay? Or it was either the day before or the day of. And it was right after he had been shot at and his ear got nicked, right? It's like he came back, and this was her gift to him. And she dismissed the entire case on the grounds that the special counsel appointment by the Department of Justice was inappropriate and illegitimate, and that you can't do it. And it's like she lifted Clarence Thomas's concurring opinion and made it her own. And so she heard what he had to say, and she did it. And now it is going to the 11th Circuit. Jack Smith filed his brief with the 11th Circuit. And the 2 questions, I'm just going to read them, was, does the Attorney General have statutory authority to appoint a special counsel, and is that consistent with the Appointments Clause of the Constitution, which is in Article 2, Section 2, Clause 2? and whether the statutes that the Attorney General invoked to appoint the special counsel constitute, quote, other law under the appropriation for independent counsels, such that using that source of funding for special counsel was consistent with the appropriation and the appropriations clause of the Constitution, Article 1, Section 9, Clause 7. So essentially, though there are two different clauses in the Constitution, the Appointments Clause and the Appropriations Clause, that specifically says what you can and cannot do. And in this particular case, and what Jack Smith said in his appeal, is that, look, there are several statutes that give the Attorney General the specific authority to appoint special counsels and to carry out law enforcement missions. Those are 28 United States Code 515B and 533(1), and that there's a long history of and tradition of appointing these and of Congress funding. And, look, when you think about the Department of Justice just generally, right, you've got the Department of Justice, you've got the Attorney General who's in charge, but then he appoints, or she, United States attorneys throughout the country, right? There's many of them. I don't even know how many there are. I think there's like 80 or something U.S. attorneys. And
those are appointed by the Attorney General, though. Is that what?
Pardon?
Maybe I misheard. Those aren't appointed by the Attorney General. Those are nominated by the president and
exactly, and confirmed by the Senate. Exactly. Sorry, I misspoke. But yes, they're appointed through the Appointments Clause, right? And then what they are allowed to do is hire AUSAs, or Assistant United States Attorneys. Those just get hired, right? They get hired by the Attorney General. They don't have to go through any confirmation of the Senate. They don't have to go through any of that, right? And the Department of Justice, if they want to create a new unit or a new bureau, they can do that, right? They can create a terrorism unit, or they can create whatever the units are, the cybercrime unit, whatever, all the different units throughout, and they can hire people that have that specialty. And I say that because, that's what they're saying the special counsel is more like, that it's an inferior officer, right? That they can appoint. And okay, so I'm just going to read the Appointments Clause. Officers of the United States shall be appointed by the president with the advice and consent of the Senate, which is what you were just saying about U.S. attorneys, right? Article 2, Section 2, Clause 2. But Congress may, by law, vest the appointment of such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of departments. And so what they're saying is, if the special counsel, even if the special counsel is more like U.S. attorneys, right, where as opposed to like an AUSA, Congress gave the Department of Justice the authority to do this through those statutes. And they provided that the Attorney General shall be the head of the Department of Justice, right? That's one statute, appointed by the president with the advice of the Senate. That's 28 U.S.C. Section 503. And Congress has vested almost all in the AG, all functions of other officers of the DOJ, including the power to prosecute all offenses, supervise litigation, and authorize any other officer, employee, or agency of the DOJ to perform any of these functions. And they also have the power to commission the special assistants. So it's just very interesting, this brief, and some of this comes directly from the brief. That Congress specifically gave the authority to the Attorney General to do this. And so, the other interesting thing about the brief is it talks about the history of, there was an independent counsel that used to exist, but then that was replaced by special counsel, et cetera. But, to say that this is not statutorily authorized is just not true. And the Appropriations Clause also, there's, saying that Congress has to approve of the money that's paid. Congress enacted a permanent, indefinite appropriation appropriation to pay all necessary expenses of investigations and prosecutions by independent counsels. And so, but the problem is it says independent counsel, not special counsel. And so Judge Cannon is like mincing words here because, sometimes they call it independent counsel, sometimes they call it special counsel, and what is it, an inferior officer? And so she's just ignoring all the statutes that authorize this. And the authorizing statutes are four of them: 28 USC 509, 510, 515, and 533. All of them authorize the special counsel appointment. And so, she just kind of, she just basically says that she kind of says, okay, Judge Cannon, this is from the brief. Judge Cannon recognized that the Supreme Court in US v. Nixon said Congress in those four statutes had vested in the Attorney General the power to appoint subordinate officers, including the Watergate special prosecutor. But she said that was dicta. She dismissed it. And Jack Smith.
Can I just interrupt to read what that Supreme Court case in Nixon says?
Yep.
And then we'll talk about what Judge Cannon said about it and how she basically says, the words on the page don't mean what the words on the page say. So here's what the Supreme Court said in Nixon. Quote, Congress has vested in the Attorney General the power to conduct the criminal litigation of the United States government. It has also vested in him the power to appoint subordinate officers to assist him in the discharge of his duties. And it cites to those four statutes that you just mentioned. Acting pursuant to those statutes, the Attorney General has delegated the authority to represent the United States in these particular matters to a special prosecutor with unique authority and tenure. What about that is not clear? It is unfathomable to me. But she's saying, they said that, but it was a throwaway, it was an aside, it didn't mean anything. It's like you said before, both of you are talking about how alternate realities, right? That things just don't mean what your own eyes and ears and senses tell you. So look, we've seen, Jack Smith appeals to the principle of stare decisis, which is when a court has already decided something, there's really a very, very heavy thumb on the scales to keep, to keep deciding consistent with that kind of precedent. But here they've shown, and we've seen it a couple of times in the past couple of years with this court, they've shown really little loyalty to that concept of stare decisis. So they could
like Roe versus Wade.
Yeah, just we don't care anymore, right? Or the administrative state, right, is no longer, even though there's decades, under Chevron that allows administrative agencies to interpret their own regulations and rules. So that's out the window too. So it could be that Nixon is out the window once it gets up to the Supreme Court, but it's not for a trial court, the lowest level federal court, to say so, despite the permission structure that one justice gave her. So sorry to interrupt, Karen. I just
no. It's a conversation. Yeah, no, you're right.
To say the actual words on the page in that Supreme Court decision, which people listening can judge for themselves what that says, because certainly Judge Cannon had a different view.
Yeah, the interesting thing was she was hung up on one word in the which was to retain. The appointments clause says that, or the statute says that he can retain an inferior officer and appoint them, as opposed to appoint or employ. So it's just interesting that. So what she's basically saying is, there's a whole long discussion of grammar, like, can you use a past participle as an adjective to describe the present tense? I was like, what the heck are they even talking about? Like, that's really what this got so detailed into that, about how to interpret this. But, there's no way that Congress meant to say that only an attorney previously hired, because what she said is basically, if you were to pluck an AUSA, someone who's already hired, out of the Department of Justice and then raise them and make them special counsel, you can retain them for that. but you can't pluck someone out of the universe like Jack Smith, who didn't work for the Department of Justice, and make them special counsel. That's essentially what she came down and said. And that just is illogical that that's what Congress meant. And it's not the plain meaning of the statute. And
I'll read that too, just so people have a broader scope here. So Section 515B empowers the Attorney General to, quote, commission attorneys who are, quote, specially retained under authority of the Department of Justice as special assistants or special attorneys, meaning special counsel. So yeah, she parsed that and said, specially retained means that they already had to have been within the Department of Justice, you know, torturing that word to death. And what Jack Smith says here is, so what you're saying is, like, if someone could be, retained for 1 second and then be made special counsel, but I, as a private person being made, special counsel, skip that 1 second test, and I can't be the special counsel. Like, where's the logic of that?
Yeah,
so
exactly.
I thought he did a good job kind of taking that to its logical or illogical conclusion.
Right, because if Merrick Garland had said to Jack Smith, I'm making you an assistant United States attorney first, and he swears to that oath, and then he immediately says, okay, and now I'm making you special counsel, suddenly that would be okay? Like, it's just stupid, I don't know.
It's just stupid. I don't know any other way. I mean, that's not like a legal term of art, but
very jargon we're using here. It's just stupid.
Call it like you see it.
It just makes no sense. So what happens next is what happens next, right? So he filed this. I guess they will reply to, I guess they will file their response, right? And then maybe there'll be oral arguments, and then there'll be a decision. What was sort of interesting, and what do you make of the fact that Jack Smith
oral argument? So.
Pardon?
He asked for oral argument, and I think a case in this magnitude will probably get it. I think I know what question you're going to ask, because there was one interesting omission.
Go ahead. Read my mind, Danya. I love it. I love it. Read my mind.
Well, because we've talked about it, Judge Cannon has been reversed pretty handily in pretty strong terms twice by the 11th Circuit already, which is not known to be a liberal circuit by any means.
In this case, she's been reversed.
In that kind of monitorship phase. Yeah. So it wasn't technically this case, but obviously adjacent. And she was reversed in a pretty embarrassing way twice by different panels, right? And including some Trump nominees, as I recall. So the question was, is third time the charm? Does Jack Smith ask for her to be recused, saying, she can't really be unbiased at this point? And notably, he did not make that request. That the 11th Circuit sua sponte could remove her, but I think it was going to be a stretch in any event. Higher courts hate to do that with lower courts who are actually their peers, sometimes in the same courthouse. In this case, no, because she sits all by herself where is she in? I don't know, somewhere.
Fort Pierce?
Fort Pierce, that's right. Yeah. I think she's the only district court judge in that courthouse. So doesn't really have peers, who will say to her, like, Aileen, you really, you kind of stretched a little on this one.
Well, they could wheel it out to another Southern District of Florida judge. I mean, she got it on the wheel too, I mean, look, I just think that Jack Smith didn't ask for it because, they know what they have they know that they have that at their disposal if they want, right? If they want to remove her, they've seen what she's done. Like, why? I think he just kept it about the law and not made it personal. That's why I think he didn't put it in there. But
yeah,
I don't know.
I agree. I mean, he's playing it down the middle. I mean, just to read this brief is to know how serious and how kind of pragmatic he is. I mean, there's no flowery language. There's no dramatic language. There's not even really adjectives in there. He's just saying that's wrong, and here's why. And so he sticks very much, to the letter of the law and kind of the rationale. As we said, he's just pointing out how irrational her decision is, and how, if she were right, then every special counsel throughout history would have been improperly appointed, and every Congress, repeatedly overlooked that pattern of errors. And the Supreme Court itself, this is his quote, failed to spot that flaw in Nixon. So he's just very matter of fact, very down the middle. And so he didn't want to take that extra step and make it appear that there's some kind of partisan flavor to this. And as you say, Karen, he'll have other opportunities. And, what is nerve-wracking is if this case does eventually proceed, at some point, a judge has the power to overrule a jury verdict. And once they do that, it's a post-trial, post-verdict decision. A judge can say, yeah, I know the jury said guilty, but I'm going to acquit him. And if a judge does that, there is no appeal from that. The government cannot appeal that. That's an acquittal. And any appeal, any attempt to prosecute would violate, double jeopardy. So that's the ultimate, hammer that she's got. So we'll see if she can.
And she's a lifetime appointment. There's nothing you can do.
Right. God. Although she's clearly angling for a different job if Trump is reelected. But so we're not there, obviously, as you say, as you said with the other case and with this case, there's going to be a lot of legal wrangling before we get to trial, and
that's why voting. That's why what we say every single show. That's why voting matters so much, and who you vote for matters so much. I love when and which is a perfect segue into our next segment with Kathleen. But it's amazing to me because one of the right wing kind of repeated over and over again statements is that Kamala Harris doesn't have her platform doesn't have any policy, right? That's been repeated, that this isn't about policy and joy is not a policy. And I think those people are missing the big picture. The policy is this election is about, do you want our democracy or not? Do you want the rule of law or not? This isn't about fracking this election, right? This isn't about what her views are on, if she's going to raise this tax or that tax. This election, make no mistake, the policy in question is, does our Constitution matter? Does democracy matter? Is our country going to be a democracy where we have a peaceful transfer of power, where women have the right to choose, where women have equal voices, to men, frankly, where, are we is the rule of law going to matter? Is the truth going to matter? I mean, that's what this election is about. And so getting out to vote and having all votes count, there's nothing more important. And so Kathleen, tell us what is going on. You just came back from the DNC, the amazing convention. And so tell us what's going on.
Yeah. So, it's been reported recently that there have been raids that were carried out in counties near San Antonio and in South Texas around the 20th of August of this year. They were conducted by the Texas Attorney General's office, who is Ken Paxton. He's the Attorney General, Republican Attorney General. And these raids primarily targeted Latino political activists and elected officials, people who have actually been elected into office. And it was under the pretext of investigating alleged voter fraud. Now, these actions are part of a much broader pattern of voter suppression and intimidation that is happening particularly within minority communities. The legal issue here revolves around the potential abuse of power and violation of civil rights. So there are local advocacy groups that are asking DOJ to open up an investigation, a civil rights violation investigation, because these raids are seen as being politically motivated and an effort to suppress voter turnout, particularly among Latino voters. Now, I think it's important I want everyone to remember that if you look at what the results of the election, the presidential election in 2016, Trump versus Clinton, just in the state of Texas, Trump won 52.6% of the vote. Clinton had 43.4%. Wasn't even close when you consider how close election results are in battleground states. look at 4 years later when it's Trump versus Biden, and the result is Trump 52.1% and Biden 46.5%, virtually identical. And it didn't matter. Trump never said anything about bad election practices in Texas post 2016. But when he loses in 2020, not only is he attacking the battleground states, but for some reason, he's attacking Texas and saying to Greg Abbott, the Republican governor there was so much fraud going on, ballot harvesting, which, basically they make it seem like they're actually harvesting ballots that belong to like people that don't exist and then stuffing the ballot boxes with them. Basically what ballot harvesting is collecting completed absentee ballots from voters and delivering them to polling places or election offices. This is, a lot of states allow this because they want to help elderly voters or people who live in remote areas to be able to get their ballots in on time. And so in order to address those vulnerable voters, a number of states have made mail-in and absentee voting more accessible to citizens. Some of the states actually say, okay, it has to be this person or that person who can actually, it has to be a family member or a legal guardian or a caregiver that has to deliver that ballot to a voting place or to a local elected official. But in the absence of that, people go around, advocacy groups go around and they collect these ballots.
And this has been done since forever. This is every election. People do this all the time. This is to help, elderly, disabled, whatever.
And the interesting thing about this is Trump was roundly criticized in 2020 by people in his own campaign. He was saying mail-in voting, absentee ballot voting is ridiculous. It's a fraud. Don't do it. I want all of my voters to show up on election day and be there physically because this is all a bunch of fraud and, it's ridiculous. People inside of his campaign were saying, what are you doing? We want to enable as many people to vote, whether they're your voters or otherwise, to vote. And of course, now his daughter-in-law, who is now one of the higher ups at the RNC, is saying that they totally support mail-in ballots. And Trump he vacillates back and forth. Sometimes it's a fraud, it's ridiculous, it shouldn't be allowed. Other times he tells people to do it. So who knows what his position is going to be.
Depends on the jurisdiction, right?
Right. It depends. Absolutely.
Detroit, it's
right,
okay in Wyoming.
Right, exactly. So, but it's so interesting when you look at why is Trump picking Texas? He won there handily. And what is the reason for this? And it's really the ultimate goal of Trump and his campaign. It's not just Trump, but, with the people around him. There are two goals as to why he does this, especially in a state like Texas, where it's not even close when he wins. The goal is to undermine the public's confidence in the electoral system. That is real. And the second very real outcome is you want to disenfranchise voters, specifically Latino voters in the state of Texas. These are people that they were knocking doors down. They were confiscating cell phones and computers. Some of these people were 80-year-old. One was an 80-year-old mayor of Dilley, Texas, Marianne Obregon. They threatened her with arrest if she didn't hand her cell phone over. This kind of stuff is just insane. And so, Trump has been pushing them to, institute new laws that make it harder for ballot harvesting or ballot collection, which is really what it is, to be done. And there was a specific Texas Senate bill that was passed in 2021 that included some key provisions that were designed to tighten election security, even though, as Chris Krebs, who was the head of this, election security federal agency, said it was the most secure election in the history.
And he worked for Trump. That guy worked for Trump.
And after he said that, he got fired by Trump. But he said it was the most secure election. There was none of this stuff that's going on, and all that stuff is crazy. Now, another reason why this is being done is because Maria Bartiromo, who is a Fox News host, she made these completely unsubstantiated allegations that this ballot harvesting harvesting, meaning just creating ballots out of whole cloth and stuffing the ballot box with them. She has been saying this since 2020, that this happened, with absolutely no verification, no backup whatsoever. And that was the reason why they did this investigation. And by the way, local elected officials in Texas looked into this and said, this did not happen. It just didn't happen. Now, Chris Krebs, again, Cybersecurity and Infrastructure Security Agency, CISA, he literally said publicly in 2020, the election was, quote unquote, the most secure in American history. So it's just absolutely ridiculous that this is happening. But the reason why I think that this is so relevant now is because Texas is not, I mean, maybe in 4 years, maybe in 8 years, it might go red to blue, but it's not considered a battleground state on a national level. The Brennan Center for Justice just came out and in a piece that was titled, "Are Swing States Ready for 2024?" And basically what they're saying is, when you look at when it became clear that Trump was likely to lose in 2020, that's when his supporters, and this started well before October and September of the fall of 2020. It happened. He started doing this in March and April. They started laying the groundwork to overturn the outcome. And they, at that time, focused on 6 battleground states: Michigan, Georgia, Arizona, Pennsylvania, Wisconsin, and Nevada. And those are widely considered the battleground states. And they were sowing conspiracy theories about fraud. They vilified and threatened honest election officials. They encouraged local and state election officials to ignore their legal obligations. They had the whole fake elector scheme. Of course, we know what happened on January 6th. So state officials in these states held firm in 2020. But the question that the Brennan Center is bringing up is, because of what's happened since 2020 in some of these states where they have tried to get election deniers elected to office, so that if in 2024 there is even a remote question about the validity of an election, it would go the other way, because they're trying to embed election deniers in these positions of people who have to certify elections at the local and national level. And so I would encourage people to read this piece by the Brennan Center, and they are widely seen as nonpartisan, and they're just asking the question, are these 6 swing states ready for 2024? And that's a real legitimate question. So I think looking at Texas, which is not a battleground state, and Trump has won handily 2 cycles in a row, it just shows you how broad this misinformation, disinformation campaign is that's coming out of the MAGA world led by Donald Trump, is with, again, the goal of just completely undermining the public's confidence in electoral results, to the point where no matter who wins, they're not going to believe it. And really a very real effort to disenfranchise voters. And again, you look at different polls, Trump's leading here, Harris is leading there. I mean, the Black vote, the Latino vote. I mean, why Trump is trying to disenfranchise anyone from voting, you can ask the question, why? I mean, some say that the MAGA base is very firm and it's not subject to, getting, maybe some independent voters or, maybe Nikki Haley voters to go with Trump. His 46% is pretty solid at 46%, but that matters where that 46% comes from. And if they come from some of these battleground states, we all know it's all up to the Electoral College. So I think this is something for people to really pay attention to, what's going on in the state of Texas, because these attempts are going to be real as the closer we get to the election. And remember, it's only, 70 days away? I think we're away from less than that, maybe, from the election. So it's really important for people. I hope people pay attention to this, because it's going to be a close race regardless of what happens.
It's going to be a close race. And it's this insidious thing that MAGA is doing to little by little to chip away and have fewer votes count. I mean, that's what this is. And it's just unbelievable to me, to hear these stories. It's not just a matter of making sure that it's secure. They're literally trying to make it so that legitimate votes aren't counting.
Yeah. I mean, and look, there are any number of reasons why people cannot vote. They're disabled, they're elderly, they're afraid it's going to be snowing or raining on election day. I mean, we should be expanding the ability for people to be able to vote. I mean, why we make it, we can come up with a secure enough system that people can vote from home. We just don't do it. So this election may, depending on the outcome, may result in really overhauling how we have elections, how we conduct them, and how we allow people to vote.
Yeah, and the scary thing is the Constitution specifically allows the states to determine the, to go ahead.
Yeah, how people vote, how they vote.
Yeah. It really pushes it back into the states, right, to determine how elections go. And so when you have so many state legislatures that are, because they can talk about like the time, the place, the manner, it really pushes it back to the states to decide. And in doing that, it really I think makes it dangerous, because so many state legislatures are controlled by MAGA now, as you call them, election deniers, right?
Yes. So let's look at Georgia, Karen and Danya. The state election board has approved rules that could empower local election officials to just withhold election certification without any clear justification. Just withhold it. Critics argue that these rules are going to create opportunities for election subversion. But I mean, this is just, given Georgia's past experience with election denial efforts, it's just unbelievable that, within these individual states, as is their legal right, these are the things that are happening. Arizona has been a focal point of election denial and subversion, both in 2020 and in local elections in 2022. They saw a state, the state saw armed vigilantes patrolling ballot drop boxes. Local officials refusing to certify valid election results. This is the stuff that's happening in these battleground states. Wisconsin has also, the state came close to overturning the 2020 election results through a series of lawsuits that were specifically aimed at invalidating votes in Democratic-leaning counties. And what prevented that from happening were election officials who upheld the law, and courts, when it got to the courts, upholding the law as well. So, but they've been doing a lot. The point is, if, using Texas as an example, now you have these raids that are technically justified by this new local law, to disenfranchise voters who primarily are either in very rural areas or are Latino from voting. So, to be determined how it goes, but Mark Elias is an election lawyer who defends a lot of these cases for, Democrats in these battleground states. And thankfully, we have a robust legal response to it. But all it takes is, as we saw, all it took was, Mike Pence saying, you know what, I'm going to listen to Donald Trump. And I think it is my ability. It's well within my ability in this legislative role for me to decline to certify the election results. And thank God he had a backbone and he didn't, but all it takes is one person.
Wow. That's just unbelievable to me. And it's terrifying. It's actually terrifying what is happening. But we got to get out and vote. And those people who can vote in person should go in person, not be intimidated. And as many people should vote as possible. And hopefully whoever wins, there will be a peaceful transfer of power. Wow. I don't know how you did it. You ran for office twice, Kathleen.
Let me tell you, it's not for the faint of heart. It is, it's really hard to put your name on a ballot. And then, of course, you rely on the legal and political infrastructure that exists to allow people to have access to getting on a ballot, putting their name on a ballot, asking people to vote for them. And you count on the legal counting of those votes and legal certification of the results. For everything from dog catcher all the way up to president. So, but that's, again, chipping away at the general public's ability to have faith in the outcome of elections is one of the biggest threats to democracy there is.
Yeah, I agree. You don't even think about it. Like, when you think about running for office, you think about so many things like, what are your policies? What are you going to do? How are you going to do it? You don't, but you assume, people assume, okay, when you get on a ballot, people vote, you assume that your vote counts, right? But the fact that that's not even a guarantee anymore is terrifying.
It is.
Of course you want to keep dead people from voting or whatever the BS stuff that they're talking about is, but legitimate people should be able to vote and have their vote count.
Absolutely. It's the most fundamental part of our democracy, really, when you think about it. Nothing else. Well, anyway, thank you for that perspective. And thank you so much for bringing us that information. I mean, it's absolutely, we have to get that out there. It's so important for people to know what is going on in these individual states, not just your own. No, try to go to sources like the Brennan Center. They don't have a dog in the fight. They just want, to preserve democracy and have the system work. Exactly. Yeah. Well, we've reached the end of another episode of MissTrial. We were going to take some questions, but Danya is having some internet issues. And I know some of the questions were about her and Michael Cohen's case against the government, et cetera. And so because she had internet issues and she's off, we're going to not address it this episode, but next time we will for sure. Yes. Great to see you. And, get out, everybody vote. We need that. I don't know how many more times to say that, but that's what we have to do. We have to get word out as much as possible. So thanks to everybody for tuning in, and great to see you, Kathleen. You too, Karen.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the Midas Touch newsletter at MidasTouch.com/newsletter.